Welcome back to This Day Live, the Sunday talk show here on the Arise News channel. I still have Professor Aworawo and also Mr. Jide Ologun today. Now, we're still on the subject of River State, and we're going to spend a little more time on this. This time, with emphasis on legal perspectives around the court decision stopping Governor Fubara's impeachment proceedings. To help out with that is Dr. Festus Ogwuche, constitutional lawyer, human rights advocate, broadcaster, legal practitioner, public affairs commentator, and principal partner of Festus A.O. Ogwuche and Cranfield Solicitors. Good to have you on the program, Dr. Ogwuche. Thank you for joining us.
Thank you very much, Dr. Abate, for inviting me and for giving me all these accolades. Thank you.
Thank you very much. Well, Dr. Ogwuche, straight to the point. The decision to go to court to get an injunction, which was granted by the court of Justice Fubara, is it a smart move on the part of Governor Fubara and his deputy, Professor Odu, considering the fact that an ex parte injunction is just a preservatory order? It doesn't necessarily vacate the matter at issue, the main issue. How smart is that move?
I would say it's a smart move. I also say that it's a constitutional process acknowledged by the Constitution. They sought to get an ex parte application, ex parte order, which was granted by the court, and it's part of what should be, because the court has the jurisdiction and power to look whether the process of impeachment was properly done and there's validity in the entire process. If there's anything regarding, of course, the fact that impeachment proceedings are time-bound, and if there's any little infraction with the constitutional procedure, it can be invalidated. So it's a smart move. It's also a constitutional process. The ex parte order stays for a given number of days before it's vacated, but then it's given pending the determination of the motion on notice. Apparently, they have a motion on notice which will involve the hearing of the application. The respondents will come and file their own counter affidavits to the injunction and their written addresses, and the court to take them holistically on the next adjourned date, then adjourn for the determination of that motion on notice. The ex parte injunction is to keep things on hold, at least for now, so that the courts can have the privilege and opportunity of looking at the nitty-gritty of the application, the complaints contained therein, and to ensure that the process is followed. Recall that constitutional process for impeachment is not a child's playground. It is very deep and it's sacred. We have seen in the case of Nyako, Morotala Nyako, that went all the way to the Supreme Court, and the Supreme Court said that it's something that should be attached with every degree of circumspect and every degree of seriousness. So it's not something that you raise simply because you want to visit a vendetta on the particular governor, or you see it as a process to blackmail, or maybe something that you can keep by the wayside. You can invoke at any time that you want him out if he goes contrary to your legislative exercise, or whatever name called.
Okay. One other thing, I get the point you have made that it's a temporary thing, it's time bound. After all, there was a precedence in the case of the present governor of Ondo State, I think in 2023, when the House of Assembly wanted to remove him as a deputy governor. He went to court also, and that precedence is established. So Governor Fubara may be entitled to constitutional self-preservation. But how about Section 188, sub 10, which some commentators have been referring to, that the courts cannot inquire into the impeachment process because of the doctrine of the separation of powers. And here you say that even the legislature is under the law within that process in Section 188.
Every process that is constitutional in nature can be questioned, and the courts have the jurisdiction to entertain them. what that provision is talking about is when the entire process is done and everything, there's no infraction and everything is done in the manner it should be. The courts cannot question whether the impeachment was wrong or right. But if the process is still on course and yet to be determined, nothing stops the court from questioning the validity of that constitutional process and to the extent to which it is consistent with the provisions of the Constitution. That's the extent to which I understand the impeachment procedure under Section 188, and that is how it applies in the United States. The only regrettable thing is that we have a situation where impeachment processes are invoked at will against governors. I think this is about the second or third one against the current governor of Rivers State. You'll be surprised that in the United States, throughout the course of the U.S. democratic history, only 11 impeachment processes had ever been invoked, and 8 of them succeeded. And it's not something that you just raise anyhow. But while in the process of doing that, the court can find out whether you met the time limits, whether the letter of letter of complaints, or what do they call it now, the notice of allegation or notice of impeachment was properly served on the governor, and whether the House of Assembly got the impeachment notices in accordance with its provisions, or if the impeachment process follows the due process established under that particular provision of the Constitution. The court has the jurisdiction, even if it is not mentioned. The court has that jurisdiction to entertain it and see the extent to which that process conforms to the provisions of the Constitution, agrees with the provisions of the Constitution. The court has that jurisdiction. It's within the civil rights and obligations of the governor and of the people interested and the people of Rivers State to understand the reasons, the procedural correctness of that provision and the process that is used to push it forward.
Okay, Dr. Ogwuche. Now, what is likely to happen? Because something strange always happens in Rivers State. Would the Chief Judge, Justice Simeon Amadi, what is he likely to do? Because we've seen situations in Rivers State where even when you say, oh, the court has jurisdiction, this is constitutional. What if the Chief Judge declines and then goes ahead to constitute a panel? Strange things happen, maybe not only in Rivers State, but also elsewhere. And then that would, create his own crisis. What do you suspect will happen?
Yes, just as you rightly put it. So the River State is turning out to be a theater of the absurd. And it's quite unfortunate. We've gone through all this how many times? And it has created a whole lot of insuperabilities in the governance mood here in this place. And the people are the ones that are suffering. We have gladiators drawing their swords and shooting them over and over. The president intervening and the Supreme Court coming in to make determinations amongst other determinations of several other courts. And this thing has not abated. One of the components, ingredients of taking elective position is maturity and a sense of responsibility. I know very well that if it gets to the stage whereby the CJ, the Chief Judge, is supposed to go ahead and do the needful in accordance with the provisions of the Constitution, he cannot refuse. But where there's an order of court and other expert order restraining him from going ahead to do that, he cannot. He's in charge of the law, he's in charge of judiciary, and it's expected that he should be the one to respect it first. He cannot defy the order of a court of competent jurisdiction, no matter how wrong it is. What is important is if there's need that the court, if it is seen that the court does not have jurisdiction to make such order, then the parties can go to court and ask the court to set this aside on the grounds that are well known, grounds that are acceptable. If the court looks at it and thinks that, well, these grounds are valid, he can strike out the case, the motion, or the case in its entirety. But if not, so long as the order is subsistent, whether it is done without jurisdiction or it is a useless order, it has no worth whatsoever, the Chief Judge of Rivers State is bound to obey it. He cannot do otherwise.
Okay, thank you very much, Dr. Festus Ogwuche, for joining us on This Day Live, the Sunday Talk Show. Thank you very much indeed.